The coins alert is where everything in this video comes from. Also, don't forget to like and subscribe to my station to get more XRP news and news about cryptocurrencies in general. Look at this now. A former official talks about the latest news in the XRP case. Now, before we go any further, there is a new crypto airdrop going on Telegram that will soon start. Make sure that you take part in this airdrop. Just below the movie, there is a link. Do not miss this. Let's watch more of our movie. The U.S. Securities and Exchange Commission has asked for a deadline to file its major brief. The suggested date is January 15, 2025. This is the latest development in the ongoing dispute between the Securities and Exchange Commission and Ripple. Some people who support XRP think that this request is just a way to create more time for the court battle, which is now in the appeal stage. This request has made people think even more about it. Some news sources say that attorney and XRP fan Bill Morgan thinks that the SEC's latest move may have been taken mainly to put things off or because the SEC is not confident in its chances. Still, Mark Fagel, who had been the regional head of the SEC before, stepped in to clear things up and put an end to the rumors about the delay. But Fagel believes that the SEC might not be purposely making the process take longer than it needs to. Not a single person is trying to add anything. The appellant has to ask for a hearing date within 91 days of giving the court certain information, according to the court's rules. The SEC has done this, which is called intent on extending anything. At this time, the appellant has to ask for a hearing date within 91 days of giving the court certain information, according to the court's rules. These steps have been taken by the SEC. Fagel said that the information he gave gives the problem a formal view. You should know that what the SEC did was legal. According to these steps, an appellant must ask for a hearing date within 91 days of giving the court certain information. Even though he said those things, some people in the XRP community are still very skeptical and don't believe the SEC will work hard to find an answer quickly. Ripple Labs has sent a Form C to the U.S. Court of Appeals for the Second Circuit that lists the reasons it plans to use in its cross-appeal. This is something new that has happened recently. The filing was backed up by a post at the same time by Stuart Alderati, who is the chief legal officer of Ripple. He said the SEC couldn't give them any new proof or ask Ripple to give them more. In his post, Alderati brings this to the attention of people who use XRP. While Ripple is going through the appeals process, the SEC's main goal is to cause distractions and misunderstanding for the company and the larger industry. But at this point, it's just background noise. The part of the fight that was hard is now over. Ripple's business is growing and getting stronger every day, even though the appeals process is still going on. Alderati says that the next step in the complaints process might not happen until January 2025. This could mean that the XRP community and the cryptocurrency market as a whole will have to wait. This is because the SEC has asked for more time to file its main brief. Through the submission of a Form C that questions certain parts of a previous court order, the California-based blockchain company Ripple has made its expected cross-appeal. The Securities and Exchange Commission had to file its major brief quickly, so this document was sent in soon after. It talks about a number of important aspects of the long-running legal battle over Ripple's digital assets. Recently, there was more progress in the case between Ripple and the SEC, which has been going on for almost 4 years. The Securities and Exchange Commission first sent its own Form CU on October 18th. This was a challenge to the part of the court's order that said Ripple's programmatic XRP trades on cryptocurrency exchanges were not securities. In its latest counter-appeal, Ripple is trying to get important parts of this decision to be looked at again. According to the most recent appeal, Ripple asks the court to help them figure out what the Securities Act of 1933 says is an investment contract. However, Ripple's argument says that the term should be used when there is an agreement that gives the buyer the right to make money from the seller's actions. Ripple, a cryptocurrency business, says that this term needs to be defined in a specific way so that other cryptocurrencies can be categorized by federal law. This could have implications for future cryptocurrency lawsuits. The court's previous decision that XRP sales met the criteria set by the Howey test is also called into question by Ripple's appeal. The Howey test is used to decide what kinds of things are considered to be secure, because it was found that Ripple broke federal securities laws by not registering sales of XRP to institutional buyers. Based on this decision, the company had to pay a fine of $125 billion. In its complaint, Ripple says that these sales did not follow the rules set out in the Howey test and asks that these transactions be looked at again. The third argument that Ripple uses is a look at the rules that the SEC has set up for regulating cryptocurrencies. It draws attention to problems with consistency that have made following the rules hard. The defense talks about its good point, which says that the rules for the sexes weren't clear enough, and that it was unreasonable to expect people to follow rules that didn't have clear standards. Ripple says that any punishments or restrictions put in place by such vague standards are wrong. The last part of Ripple's appeal is about the court's order. This order is meant to stop Ripple from breaking securities rules again when it sells things in the future. In order to get the court to spell out what groups that have to follow Rule 65 of the Federal Rules of Civil Procedure are responsible for, they have asked the court to provide more information. As a result, Ripple has asked the court to make the responsibilities clear because they still don't understand the injunction's terms. Recently, there was new information in the California Ripple case. A judge from the U.S. District Court made decisions on several moves. The case that is still going on between plaintiffs who say the cryptocurrency business broke securities laws became more clear after these orders. Since the court is getting ready for a hearing session on December 19th and jury selection on January 21st, 2025, the people who are suing each other over XRP have set up settlement talks. Based on Judge Hamilton's ruling, which gave orders on 4 Daubert rule applications, it was clear that the plaintiffs mostly won. The court did not agree with Ripple's request to exclude the expert evidence of the plaintiff, Jeremy Clark. The court also didn't agree with the plaintiff's plan to not allow safety names as evidence. The plaintiffs, on the other hand, asked the court to throw out the evidence of Alan Schwartz, the defendant's expert, and Ripple asked the court to throw out Jude Selledge, the plaintiff's expert. His report on the state level was considered reliable by the court, which emphasized that the XRP ledger relies on Ripple and that the distribution of XRP is good for business. Ripple said that Clark didn't know much about XRP, but the court thought that his proof was solid. The information given is not meant to be taken as trade advice. Any purchases made based on the information on this page are not the responsibility of the people who made them. Before making any investment decisions, you should definitely do your own study and talk to a professional who knows what they're talking about.